following the Trump era. My name is Anthony Gonzalez, and I'm the Vice President here at the Toledo Student Chapter of the Federalist Society. I have the distinct pleasure of introducing two of our speakers today. First, our speaker is Professor Joshua Blackman. Professor Blackman is an associate professor at the South Texas College of Law who specializes in constitutional law, the U.S. Supreme Court, and the intersection of law and technology. He attended Penn State University and received his J.D. magna cum laude from George Mason, now Antonin Scalia School of Law. Professor Blackman is the founder of the Fantasy SCOTUS and is the author of several books, including Unprecedented, The Constitutional Challenge to Obamacare, and An Intro to Common Law, 100 Supreme Court Cases Everyone Should Know. Our commentator today is Professor Lee Strang. Professor Lee Strang is the John W. Stopler Professor of Values here at the University of Toledo College of Law, who specializes in constitutional law, property law, and religion and the First Amendment. He attended the University of Iowa Law School, graduating Order of the Cloth, and received his LLM from Harvard Law School. During the fall of 2015, Professor Strang was a visiting scholar at the Georgetown Center for the Constitution, and in 2016 he was appointed to the Ohio Advisory Committee of the U.S. Commission on Civil Rights. Please join me in welcoming Professor Blackman.
Thank you so much. It's a pleasure to be here, and this is my first time in Toledo. I clerked in the Sixth Circuit for Judge Boggs in Louisville. I spent a lot of time in Cincinnati, never quite came up here, so it's good to be here. And thank you to Carl and Anthony for inviting me, and my good friend Lee for providing some comments. I understand this gave a faculty meeting that you had to skip? Well, I'm sure you're devastated to skip a faculty meeting. The topic today is executive power, which is ostensibly about President Trump, but this is an issue that goes far beyond President Trump. And I want to start with a case you probably studied in constitutional law called Youngstown Sheet and Tube Company versus Sawyer. Now, how far are we from Youngstown, Lee? Are we pretty close? No. 4 hours? Okay, in the ballpark, okay. Youngstown was a famous case decided during the Korean War. What were the facts? The steelworkers at mills across the country were threatening to go on strike. At the time, we were fighting a war in Korea, an undeclared war, but a war at least. The president decided that he would prevent the workers from going on strike. How would he do this? He would take ownership. He would seize control of the steel mills. Basically, he would nationalize the mills, right? This is the sort of thing we see in Latin America all the time. And he did it, right? He sent his Secretary of Commerce to say, you are now taking ownership of these steel mills. You can imagine the steel mill owners were not happy with this because now their private property was seized and there was no compensation that was paid. The workers also were not very happy. They wanted to go on strike. The way it works is when you go on strike, you sort of walk off the job. But when the government owns your steel mill and you walk off the job, guess what? You're going to be arrested. So this was actually bad for both parties. No one wanted this. The steel mill owners went to court and they challenged the constitutionality of the steel seizure. It's called the steel seizure case. And remarkably, a federal district court judge in D.C. ruled against the president. That was significant, right? That you're in the middle of a war. The president says, I need to do this to secure the homeland, right? Make sure we have enough steel for the troops abroad. And then a federal judge says, no, you can't do this. We have a long tradition in this country of judges saying some pretty outlandish things and the executive complying. In that case, the government appealed, and the lower court put the Court of Appeals put the lower court ruling on hold temporarily, with one condition: an appeals filed immediately at the Supreme Court. About a week later, the Supreme Court agreed to hear the case. This entire dispute went from the trial court to the Supreme Court in about a month, which is pretty darn fast. Ultimately, the court ruled against President Truman by a 6-3 vote. 6-3 was a pretty close vote. The majority opinion was by Justice Hugo Black. Right? Justice Black said, well, let's be very formalistic here, right? Let's be very stringent. Does the text of the Constitution give the president the power to take property? No, the power belongs to Congress. Therefore, the steel seizure is unconstitutional. You had an opinion by Justice Frankfurter, who was a bit more of a pragmatist. And Justice Frankfurter says, well, let's look at it this way, right? We can't decide this case based simply on clauses of the Constitution. We have to look at the executive branch practice, right? If George Washington seized private property, and John Adams seized private property, and Thomas Jefferson seized private property, if there was a systematic, continuous, unbroken chain of executive practice in which every president took property, well, then maybe Truman can do it, but there's not, right? This was a novel exercise of executive power. But then we get to the most important concurring opinion, the one that students still study for years to come. And that was the opinion of Justice Robert Jackson. Robert Jackson was a fascinating guy. He grew up in upstate New York. He went to law school but never graduated. He became an attorney in the Roosevelt administration, became the U.S. Solicitor General, that is the top lawyer before the Supreme Court. He later became the United States Attorney General. He saw firsthand with his own two eyes, how President Roosevelt prosecuted World War II, how President Roosevelt used broad executive powers to engage in military action abroad. He saw it with his own eyes. But Jackson became sort of disillusioned. He became upset by what he saw as this expansion of executive power. And he worried what would happen if the executive could start doing things without Congress providing a check. Justice Jackson was candid. He said, look, the Constitution, the text, right, this little book which I carry around next to my heart every day, right? This little book does not give us a lot of answers. It really doesn't. We can't base our law on isolated clauses of the Constitution. Instead, Justice Jackson said, we have to look to the balance of powers between the executive branch and Congress, right? So he made these three zones, these three tiers, what we might call tiers of scrutiny, perhaps, in another context, of how to assess the relationship between the president's powers and the powers of Congress. So you have an easy case, right? Where the Congress says, Mr. President, we give you this power to do something. And the president says, you know what? Thank you, Congress. I also have my own power. When the president's power is combined with the congressional power, when they're on the same page, that's a very good sign this action's lawful. And the court should be deferential to this action. The court should be very respectful when the executive branch and the legislative branch concur. Then you have the opposite case, right? Where Congress says, no, Mr. President, you can't do this. And the president says, you know what? I'm going to do it anyway. I have my own power to do it, right? It's here, Jackson says, that the deference sort of disappears. Rather than presuming the action is constitutional, what you might call a presumption of constitutionality, in this bottom tier, that presumption is reversed. There is no presumption of constitutionality. Maybe you call it a presumption of liberty or something else, right? Where you presume that the government's acting unlawfully. What about where it's not clear, right? What about where it's not clear if Congress approved it or disapproved it? It's not clear what the president's powers are. Here, Justice Jackson described the famous zone of twilight, the twilight zone, if you will, where presidential power is in this sort of this hazy middle region. Now, Youngstown itself was an easy case. Congress told the president, no, you can't take these mills, and he took them anyway. This area is what Justice Jackson called the lowest ebb, right, of presidential power. Right, the lowest ebb, that was the title that Anthony mentioned a moment ago, which is the title of this talk, the lowest ebb of presidential power. And think of, the ocean, right, when it's very low tide, the water goes all the way out, it's very shallow, right? The lowest ebb of presidential power is where the president tries to act alone and he does not have the support of Congress at his back. And when the president's acting on his own power, not based on a congressional delegation, then the courts are downright skeptical. This has been the framework that courts have more or less looked to for the last, 50 or 60 years, right? Even though Justice Jackson was only a concurrence, his opinion has been treated more or less as controlling. And look at cases like James and Moore versus Regan from 1981 for guidance. This case involved the Iranian hostage crisis of whether the president the power to suspend any lawsuits against Iran. Fun fact, who was Justice Jackson's law clerk when Youngstown was decided? A young William Rehnquist, the future Chief Justice. Yes, the future Chief Justice clerked for Justice Jackson when Youngstown was decided. Another fun fact, Justice Rehnquist wrote Dames and Moore, which cited his boss's old opinion. One more fun fact, who was clerking for William Rehnquist in 1981 when Dames and Moore was decided? John Roberts, the current Chief Justice. So you basically have this chain where when Youngstown was decided, Rehnquist clerked for Jackson. And when Dames and Moore was decided, John Roberts clerked for William Rehnquist. This is sort of fun historical oddities that only I appreciate, but I'm sure you do as well. But that's our framework, right? We ask, has Congress authorized this power? And generally when there's an authorization from Congress, the courts are deferential. Okay, sounds good. Let's fast forward to the modern era, right? And let's talk about some controversies that have arisen in recent time over executive power. And I'll focus primarily on immigration, but there are other areas as well. Whenever you hear a story in the news, does the president have the power to do X, right? Does the executive power exist? You don't always ask about, is the president asserting a power from the Constitution itself, right? It's sort of a misleading question. Instead, what you're really asking is, has Congress given the president this power, right? Has Congress given the president the power to do X? Now, what makes this question more difficult than you think is that Congress does not pass precise statutes. Congress passes general statutes. For example, Congress passes a law that says the president shall have the power to suspend entry to aliens he deems detrimental. The president shall have the power to suspend entry to aliens he deems detrimental. Doesn't give a time limit. Doesn't say what detrimental means. Doesn't say which countries this can apply to. Or you might have a statute that says the president has the power during a national emergency to spend certain amounts of money. Doesn't say what an emergency is. Doesn't say how long an emergency might last. Doesn't really say what he can spend money on. It's pretty broad. Or maybe it says the president has the power to set priorities in immigration enforcement. Sounds reasonable. Does that allow the president to have a policy like DACA, for example, which deprioritizes deportation of perhaps 1 million people, right? All of these questions turn not on what constitutional authority the president has. It's not President Truman saying, I have the Constitution, I can seize the mills. Every major controversy we have today does not turn on the Constitution itself. Rather, these controversies turn on congressional delegation of power. So all these cases depend on the question, what did Congress actually give the president the power to do? Are we in the first zone of Justice Jackson's delegation, or are we in the lowest ebb, the third tier of Justice Jackson's delegation? Everyone with me so far? Very good. So I want to talk about a few examples that have come up in recent years. The first example was a case decided by the Supreme Court in 2018 called it's called the travel ban case. The case was actually titled Trump against Hawaii, right? We all know the story. During the 2016 campaign, Donald Trump said over and over again that he wanted to impose a ban on Muslims entering the United States. He said it a number of times. He then said something else. He said, well, not a ban on Muslims, but a ban on people in certain territories which are predominantly Muslim countries. He gets into office, and about a week into office, he announces the first travel ban, which suspends entry to virtually all aliens from a handful of Middle Eastern countries, Iran, Iraq, Syria, and a few others. This goes to court, and it presents the question, does the president have the power to do this? So we have a statute, right? The statute says The president has the power to suspend entry of aliens that he deems detrimental. I'm paraphrasing a little bit. Okay. Now, how do we approach this statute, right? That's a very broad power, right? To suspend entry to aliens he deems detrimental. The statute does not specify how many aliens. 1, 10, 1,000, a million? It doesn't say what detrimental means. Does that mean people who pose a national security threat? Does this mean people who you're suspicious about? Does this mean people who perhaps might be uninsured? This is actually a new version of the travel ban, right? The president wants to deny entry to people who have no insurance, right? What does detrimental mean in this context? There's also the question of timing. How long can this go into effect for? There's another issue, of course, of whether the president's policy violates the Establishment Clause because it favors Christianity, or perhaps the Protection Clause. I'm going to put those aside for the moment and just focus on the executive power. A couple lower court judges were skeptical of this executive action on separation of powers grounds. And they argued like this, said, look, we know that Congress has primary authority of immigration. And we know that Congress can give the president the power to enforce immigration laws. But this policy goes too far. If Congress can give the president the power to deny entry to anyone he wants, it basically gives him this ultimate authority that trumps all their immigration laws, right? Because if the president can stop anyone he wants at the border, that renders almost superfluous every other immigration statute. Therefore, they say the president actually has not just executive power, but a legislative power. Right? In other words, the president then has the power to actually make laws. The power to make laws? How can the president do this, right? This is what's known in the law as the non-delegation doctrine, which you may have studied in common law. It's the idea that Congress cannot delegate legislative powers to the president. The legislative powers must remain within the legislative branch. But of course, Congress gives rulemaking powers all the time to these agencies. They do it all the time. If you take administrative law, you know this well. The entire Code of Federal Regulations are not enacted by Congress, they're enacted by various agencies. So what did the Supreme Court do? They sort of dodged the question. They said, well, this is a broad power, but it's somewhat limited, right? The finding of detrimentality is significant, and also the president must assess specific groups of aliens. Okay. But this avoids the more difficult question, right? What happens if Congress, in fact, gave the president the power to effectively make laws? Right? Congress gave the president power to effectively change the law. Okay, so let's go to another example of immigration that's come up in recent years, which involves the deferred action policies. In 2012, President Obama announced a policy known as DACA, Deferred Action for Childhood Arrivals. This executive action is a policy I happen to agree with. I think it's a good idea, but I'm a little bit skeptical on the legality. So what was DACA? DACA said that if you came to this country as a minor, you've gone to school, you've stayed out of trouble, you've not had any criminal background, you can get what's known as deferred action. What is deferred action? A couple things. First, your removal is deprioritized. That is, you are no longer a priority for deportation. Okay. But it does stuff beyond that, right? It also gives the president the power to give people work authorization and access to other federal benefits. It's not an amnesty, it's not a citizenship grant. People are still, they're still not citizens, but at least for the time being, they have this policy in which they have all these federal benefits. Okay, again, I think this is a wonderful policy, but does Congress have the power to give the president this authority? There's no express statute that says the president can grant deferred action. It's sort of understood within this broad miasma of administrative law to exist. We have one statute that says that Congress gives the president the power to set immigration priorities. And that's all it says, priorities. And there's another regulation that says if people have deferred action, they can get work authorization. Do these sort of collections of statutes, right? Do these sort of collections of statutes, when compiled, give the president the power to grant deferred action to up to 1 million people, perhaps more? And I've argued in a couple of briefs and elsewhere that the answer to that question is no. And it's a very similar issue of the travel ban, right? If the president has this broad authority given to him, does it cross the line from mere executing to executing the law and move over to the scope of actually creating law? And I have argued in the past that DACA and similar policies are lawmaking in general. Okay. Maybe I'm right, maybe I'm wrong. Fast forward a couple of years, and then we have the election of 2016. President Trump attempted to wind down or rescind the DACA program. Now, DACA was created by executive action. There was no notice and comment rulemaking. It was sort of just announced out there. And one would think that a policy created through executive action could be rescinded in the same fashion. Although the Supreme Court had the courts have had a different opinion. President Trump, when he announced that he wanted to wind down DACA, said, I've determined, among other things, that DACA is illegal. And to avoid future litigation, I'm going to wind down the policy. A number of federal judges have said that that is not an adequate rationale, right? That is not something that Congress has authorized as a good enough reason to suspend this executive policy. And the Supreme Court has granted review. And I think this case will be another example in which deference is ultimately given to the executive. And let me explain why. The president has a constitutional oath, a constitutional obligation to take care that the laws are faithfully executed. And how is the president supposed to know what that oath means? Perhaps one answer is that the president simply defers to the courts, that any sort of constitutional debate that comes up, the courts have to give an answer. Maybe that's one answer. But generally, the president has a duty unto himself to decide what his oath of office means, right? Just think of any executive branch official. If you are a police officer and you're deciding, can I pull this person over to a probable cause? You don't need an opinion from a judge first. You make a judgment. Or if you're a federal officer and you want to pat someone down, right? Is there reasonable suspicion? You don't need to go to a judge first. You can make that decision yourself. So the executive branch has a duty unto itself to decide what the Constitution means, at least in the initial sense of the scenario. Why is this important? Because the president said, I found that DACA is illegal and has constitutional defects, and I want to suspend it. I think ultimately the courts will give deference to this sort of decision precisely because it's framed in constitutional overtones. That is, that the Constitution itself gives the authority to the president to wind down this policy. But we'll see. The court has its cases here. Maybe they'll rule for the president, maybe not. Let me give another example of recent executive power conflicts. And that is one that thankfully we're done with, although maybe it's not done for sure, which was the Mueller investigation, right? This was the never-ending investigation, it seemingly never actually ended, but the seemingly never-ending investigation into the president. And there were two major constitutional questions that were lying in this issue. The first was, could the special counsel, Robert Mueller, issue a subpoena to the president? That is, request documents or perhaps request a deposition with the president. He didn't do this. We didn't have to deal with it, but I'll talk about it anyway. The second question was far more pressing. Could the special counsel have indicted the president, or at least recommended the president for an indictment? An indictment, if you haven't taken criminal law yet, is where you basically are charging a person with violating some sort of crime. Okay? It's like my charger thing got knocked out. Kept. All right, everyone with me? All right, so the first question about the subpoena I think is actually very difficult, right? The first question about the subpoena I think is actually quite difficult. When you have an executive branch official, he is usually under the supervision of someone else, right? If you have the Attorney General, if you have the Secretary of State, or if you have just a random employee in a federal department, right? They're subject to supervision. So there's no question that the executive branch could investigate someone who is within the executive branch. But the analysis is turned a little bit differently when the person being investigated is the president. And the Supreme Court has said a few different things which are a bit in tension. So you have one case from the early days of our country with Chief Justice John Marshall and Thomas Jefferson. We have a treason trial with Aaron Burr. Who's Aaron Burr? You may know him as the guy who shot Alexander Hamilton if you saw the musical, but he was also the Vice President of the United States. And after Burr served as Vice President of the United States, he actually was charged with treason. He probably was innocent. He probably did nothing wrong, but he was being set up for something. Aaron Burr demanded in his defense that the president, Thomas Jefferson, turn over some documents. And Chief Justice John Marshall, who was presiding at the trial, ordered Jefferson to turn over these documents. Jefferson basically said, I'm going to summarize a long trial. No, I will not comply, but here's some documents, right? In other words, Jefferson said, I don't have to follow this, but he gave some of the documents, right? And the value of that we can debate for many, many years. Fast forward to the Nixon episode. You'll recall that President Nixon was being investigated for the Watergate cover-up. What happened? President Nixon had these secret tape recorders in his office, in the Oval Office, in which he recorded conversations. And at the time, a special counsel demanded access to these recordings. He needed them as part of a prosecution of people involved in the Watergate offense. President Nixon said, no, you can't make me turn these over. And one of his arguments was this. He said, I am the executive branch. I am the president. You cannot make one of my subordinates order me around, right? You can't make this lowly special prosecutor demand that I turn over these documents. And the Supreme Court unanimously ruled against President Nixon. They said, oh, in this context, you can demand that these documents be turned over. Now, it was sort of unique because it was part of a criminal prosecution, whereas with Mueller, it was just an investigation. There's no prosecution yet, but I think that's an important fact. Okay, then fast forward to the 1980s. Congress created this position called the independent counsel, right? This was something different. This was not an executive branch employee in the traditional sense. The independent counsel existed sort of within the executive branch, but not. In that the executive branch could not fire this person at will. They had to basically give a justification and persuade a court that the person deserved to be removed. Indeed, the executive branch didn't even appoint this person. It was appointed by a bunch of judges. This entire regime was challenged in a case called Morrison against Olson in 1988. And the Supreme Court upheld the constitutionality of the independent counsel statute. They ruled that this was a valid exercise of congressional power, even though the executive branch didn't like it very much. Okay, fast forward a few more years, the 1990s, and we have the Clinton investigation, right? President Clinton was investigated for almost his entire presidency by an independent counsel by the name of Ken Starr. What was Ken Starr investigating? Well, a lot of things. You're laughing. The investigation actually started with some boring stuff called Whitewater. You know what that is, right? This was a series of land transactions from Arkansas that the Clintons were implicated in. I can't even remember, maybe Lee remembers, what actually the implications were. It didn't matter. Because what started off as an investigation of Whitewater quickly spread to sex, right? You had allegations that Bill Clinton had an affair with Monica Lewinsky in the White House. You know the deals. You know the details. Ken Starr was of the opinion that he could issue a subpoena to the president. Now, it never got to that because Clinton agreed to voluntarily sit for a deposition. And it was during this deposition that he perjured himself. He lied under oath. And it was on this basis that he was actually impeached for obstruction of justice and perjury, among other things. So the ability of the special counsel to actually get the president under oath led to his impeachment in part. Bill Clinton was a very smart lawyer, and even he talked himself into a perjury charge. Just imagine what President Trump would have done. It would have just been the entire thing, just like one long perjury statement, just the entire, like, for 90 minutes. It just the transcript. Okay, perjury, 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 just the entire transcript. So you can imagine that would have gone, right? But Ken Starr also thought that he could have indicted the president, right? That even after the president was acquitted by the Senate, that is not removed from office, Ken Starr was of the mind that he could have removed the president from office. He could have indicted the president in criminal court, the sitting president. Now, no one disputes you can indict a former president, right? So let's say that the president loses in 2020, he can be indicted later for whatever. I don't think anyone disputes that. But the question is, can you indict the sitting president? And this raises, I think, a very, very, very difficult question, right? Let me give you a couple instances. One, the mere fact that you're indicted doesn't mean you're tried, right? That is, you can be indicted today, and then the trial happens in a couple years. But on the flip side, the mere act of going through the indictment process may cause distractions from the executive, right? It may take away from his duties, which only he can execute, right? Most people in the government, they can't do their jobs, they hand those powers over to a deputy, right, or someone else. President can't hand his powers off unless he's actually removed by virtue of the 25th Amendment, which is a very complicated topic. It's him or no one else. So the president can't let someone else do it. Right? Imagine that somehow the president has a trial scheduled during the middle of his term for a criminal matter or a hearing, and then there's some sort of emergency. He says, "Your Honor, I need to leave." Right? Usually, can you do that? Say, "Your Honor, I gotta leave. We gotta suspend the trial." You don't get to do that, but the president might be able to. There's also beyond the practical issues, the separation of powers question, right? How can a subordinate of the president indict the president? Usually, you would just fire the damn person, right? If one of your subordinates says, "I'm going to indict," you're going to fire him. But in the case of Ken Starr, President Clinton at the time could not fire the independent counsel because of the structure of the independent counsel. This is why, for example, Justice Scalia said this entire structure is unconstitutional. Okay, but never got to that, right? Clinton agreed to do some stuff which made the issue go away, and President Clinton was never indicted, he was never subpoenaed. But people sort of soured on the special counsel statute, the independent counsel statute. Said, well, this is not the best idea, that we basically took, 6 years of presidency doing nothing but investigate him. Nothing ever changes, right? It's just this nonstop investigation. And Congress allowed the independent counsel statute to expire. The way it worked was if it had to be renewed, I think it was every 10 years or 8 years, and if it wasn't renewed, the law just goes away. Okay, so now we get to President Trump. In 2017, President Trump fired James Comey, who was the FBI director. We all remember this. And at this time, there was suspicion of collusion and all these other things, obstruction. The Attorney General had recused, so the Deputy Attorney General, Rod Rosenstein, appointed Robert Mueller as a special counsel. And over the next 2 years, you had this sort of dance where Mueller wanted to subpoena the president, get him under oath, and the president kind of just kept dragging it on and on and on. And then eventually we get to the point where Mueller says, okay, forget it, it's not going to happen, and he ended the investigation. And he issued his report. This long, was it 700 pages, it's this long report. I did not read the entire thing, I read large parts of it, but I did not read the entire document. But this report, I think, illustrates the difficulty of having an investigation within the executive branch, precisely because he couldn't get the information he wanted. Right? So Mueller did not indict the president, he didn't subpoena the president. But I think we may see an even more difficult question with state officials serving a subpoena to the president, and maybe even a state official trying to indict the president. So here's your question. All right, it's a good final exam question for Lee for your final exam. Could the Manhattan District Attorney indict the president for crimes committed before his inauguration? Whatever it is, it doesn't really matter. I'm sure they'll find something, right? But could he be indicted beforehand? And this raises a very tough question of the division between the separation of powers, between the powers of the state and the powers of the federal government. And I'll finish with this one point. I'll go on to Lee. You also need a case called McCulloch versus Maryland. Remember this one? Right? McCulloch v. Maryland, old school case. about whether the Bank of the United States could be taxed by a state. And the Supreme Court had this long opinion, complicated, but they basically said that state institutions cannot destroy federal institutions, right? That a state cannot tax a federal bank out of existence. And I think that's a useful lesson here. If a state could destroy a sitting president by locking him up in jail, that would do a hell of a lot more damage than taxing a federal bank. So I think there are very good reasons why these state charges against the president have a lot of problems. But just this morning, a federal court in Manhattan ruled that a subpoena could be issued to the president, sitting president, a criminal subpoena. Immediately, this is over tax return, by the way. The Court of Appeals put this one on hold, which I think was a good idea. But we're gonna have these issues pop up nonstop, over and over again. And they all go back to this sort of divide, right? What is the power of the president, and what are the powers that Congress gave him, right? Are we at this apex where the president and the Congress are on the same page? If so, no one's involved, everyone's happy. Or are we at the lowest ebb where the president's only asserting his own powers and the courts have to become perhaps more scrutinizing? All right, thank you so much, and I welcome your questions. Okay. Thank you. Oh, you can go for it.
So thanks so much, Professor Blackman. He is one of the nation's experts on executive power, in particular in constitutional law in general. And I was amazed at all of your ability to recall the who did what when, not
No
just
notes either.
what's that?
No notes either.
And no notes either. And because there's been a lot going on over the last, depending on how you parse it, 3 years or 11 years. Professor Blackman started off with Youngstown versus Sawyer, and he identified the Jackson analysis. It's the analysis that people use when they're attempting to evaluate the licitness or the constitutionality of the president's actions. And Professor Blackman went through a number of modern cases or controversies from using that perspective. And I'd like to hear more about what he thinks of one of the premises of Justice Jackson's opinion, which Professor Blackman identified, which was Justice Jackson said that the executive power is something that's indeterminate, is the language we would use now. It's more like the Pharaoh, Saint Joseph interpreting the dreams of Pharaoh was the aphorism that he had used. And I'd like to hear what Professor Blackman thinks about the truth of that, right? So to the extent that that's true, then Jackson's analysis may be an appropriate way to evaluate executive power claims. To the extent that it's not, what would be the way that a Justice Blackman, if the heavens opened up, how would he decide a particular case? And that's related to the second point, which is, to what extent is executive power indeterminate? There have been controversies, as Professor Blackman identified, throughout American history over the scope of executive power. And is it something in executive power that makes us have those continual controversies, or is it something else that's doing that? So that's one question. What does the Constitution really say about executive power? Is Jackson right in his premise and then in his conclusion? Second question is, so Professor Blackman identified a series of controversies stretching to the beginning of the Republic, but with many of them focused over the last 11 years or so. And does he think that this is a situation where both sides of the political aisle view themselves as having been burned in different occasions by different presidents? That previous statutes that previously delegated robust, at least theoretically robust, discretion to the president maybe weren't exercised to their fullest extent, and because of changing political circumstances now are exercised to the fullest extent. And so is there a consensus existing, brewing, that would suggest that both parties go back to in Congress and limit executive discretion through more narrow delegations in the future? So those are one's a more theoretical question, one is more a political practical question. Thanks.
Thank you so much. Okay, we're good. So I think but the first thing that Lee mentioned is about Jackson.
Right? And Justice Jackson has this great line where he said, to try to look at the clauses of the Constitution and figure out what the powers of the presidents are is like Pharaoh and Joseph. Remember, there's a great story in the Old Testament where Joseph tries to interpret Pharaoh's dreams. whereas it was 7 years of feast and 7 years of famine, right? How to interpret these dreams. And Jackson says basically that the Constitution doesn't give you any sort of guidance. Now, as you can imagine, I am not the biggest fan of this methodology because if Jackson is correct, that our written Constitution doesn't really tell us anything, then what are we doing, right? What are we doing as judges? Are we really willing to say that, well, the Constitution's silent, so we have to go on the non-written Constitution? And what exactly is that? What does that mean? What does that entail? You know, you're fortunate. Lee is one of the leading experts in the country on what's known as originalism. And I'll tout his new book, which came out a month ago. I encourage you to pick up a copy through the library as a copy if you need it, or, yeah. If you don't want to buy it, go to the library. I'm sure they have a copy. But students don't buy books unless they have to. That's what I found. I have a book also called 100 Supreme Court Cases Everyone Should Know. If you're taking con law, buy a copy also. But buy Lee's book first. But there's a common criticism over the text of the Constitution. It goes a bit like this. Well, there are some things that are clear, right? The president has to be 35. Well, that's easy, right? Everyone agrees on that one. And the president has to be a natural-born citizen. Oh, that's a little more dicey, right? What about someone who had a cesarean section birth, or is that a natural birth, right? You know, these sorts of questions the professors love to argue about. Then we get to other things that are much tougher, right? What does the power to declare war mean? Does that mean that Congress merely says, okay, we're in war, okay, now we're in peace, right? Is it just declaring, or does a declaration of war actually give the president power? Does the president have the power to use military force absent a declaration of war? This is a question as old as the Republic. Thomas Jefferson, for example, used military force against the Barbary pirates without congressional authorization, right? What does the phrase commerce mean in the Constitution, right? What does it mean for law to be necessary and proper to carry into execution the foregoing powers? What are the executive powers vested in the president? What does it mean to be the commander-in-chief of the armed forces? Right? These are not easy questions which have perplexed and divided our country since the beginning. Even in a case like McCulloch versus Maryland of the Bank of the United States, you had a debate. Thomas Jefferson, James Madison said, no, you can't do this, no bank. Then you had Alexander Hamilton, right? Adon Ham, right? Alexander Hamilton said, yeah, you can do this. So it takes Jackson's criticism. It's not novel, right? There's always been this sort of caution against focusing on texts because it's often hard, and people who are very smart can disagree in good faith on what the document means. But that's not a reason to reject the document altogether, right? That just means maybe you have to work harder. That means maybe you have to use different tools and methodologies to find the meaning of the text. Because if we really take Jackson seriously, then judging is merely an enterprise for judges, and then the text matters actually very little, right? And I'll use an easy example. One common criticism is that we should not be governed by the dead hand. That is, people who are long dead, a bunch of dead white guys, right? Should not be telling us how to run our republic. If that's the rule, right? If that's our rule, then what about statutes? We have a lot of statutes that are quite old. 10 years old, 10 years old, 20 years old, 30 years old, 50 years old. We have statutes that are 100 years old. We have antitrust laws that are from the turn of the century, my goodness. You think the antitrust laws decided in the 19-teens can decide whether Facebook or Google is a monopoly? These are old laws. So this dead hand, if we take it seriously, means that at some point all written law must lose its force. And this is an argument that I think I have a lot of trouble with, because at this point, why have a legislature, right? Why make laws if at just some point a judge can say, you know what, this is not with our times anymore, we'll just move on. And at that point, you're in a rule by the robes, which I don't think anyone actually wants. Now, I concede that there are problems with trying to find the answer to executive power questions, but Youngstown is not one of those cases. I think this is an easy one. And of all people, Justice Douglas Justice William O. Douglas, Mr. Penumbras, right, and Emanations, had a textualist argument. He says it like this. What happens when the government takes property? They got to pay, right? They have to pay for it. Which branch of government has the power to pay out money? Not the executive. The executive can't take his hand to a cookie jar, right? He can't go to the treasury and take money out. Congress can do it. Therefore, because the taking of property requires payment, and only Congress has the power to pay money, therefore, Congress has the power to take property, not the executive. Look at that. It's flawless. I mean, I am not a Douglas fan, but he gave a perfect textualist opinion to resolve a major case. Justice Jackson didn't need to figure out the Pharaoh's prophecies, right? The dreams of Pharaoh. Just look at the text of the Fifth Amendment, Article 1, appropriation power. So I think you'll find that Jackson was speaking of a controversy that was not the one before them. There are other cases in which I concede it's a close call, right? It's really not easy. And maybe the answer is in those cases the court should kind of stay out altogether. That if there's some sort of question that's this difficult and the political branches can't resolve it, maybe the court should say this is not for us altogether. But the flip side is there are a lot of cases where you can resolve it. And you can make an educated guess. And I think people in majority and dissent on good faith reach different conclusions. But I think that's a virtue of the sort of textualist framework, not an indictment of it. Okay. I forgot your other question.
There's a consensus that Congress should have narrow delegations.
Oh, good. Thank you. Thank you, Lee. I'm sorry, I guess I got carried with the Pharaoh stuff. The second question that my good friend Lee put was about delegation. And this is one you should keep your eyes open for. The Supreme Court has said very little about the delegation power. Right? Since the 1930s, the New Deal, the court has basically said, we're not going to get involved in deciding if Congress gave the president legislative powers, so long as Congress gave some principle, what's called an intelligible principle. Right? So long as Congress gave some intelligible principle of what the executive should do, that's fine. So for example, Congress says, the president shall regulate the air so that it's clean. I'm exaggerating slightly, right? The president shall have the power to ensure that water is clean. The president shall ensure that the airwaves, the radio waves, are used for the public interest, whatever the hell that means, right? The courts have upheld these delegations. But, my friends, I think change is afoot. Change is afoot. We had a decision last year from Justice Gorsuch in a case called Gundy. What was Gundy about? It was actually a criminal law case, right? The Attorney General had the power to designate people as sex offenders whose offenses were committed before federal law existed, right? So, person is a sex offender on date number 1, and on the future point, Congress enacts a law how to govern sex offenders, right? Usually that's what's called an ex post facto law, right? You can't send criminal liability going backwards. But they say, no, this is not criminal, it's civil liability. Okay, fine. But the Attorney General can basically decide almost anyone he wants is now subject to this regime. It wasn't Congress making these rules, it was the executive. A narrow majority, and I say narrow, it was 5 votes, it was pretty much 4, said that that's fine. Justice Gorsuch wrote a dissent said, well, we need to revisit this, right? If the Attorney General has the power to designate anyone he wants as a sex offender, that's unbridled executive power. There's no guidance. This is lawmaking. He got 3 votes. Kavanaugh was not yet on the court. And Justice Alito said, well, I pretty much agree with Gorsuch, but I'm going to go along with this just to give it a majority opinion, right? We'll come back to this later in a different case. So this is a case where I think left and right are not in the same vicinity, right? This is a pro-criminal defendant case, right? Where basically the progressives in the court upheld a law that, or a rule that allows the Attorney General to designate people sex offenders. We'll get another case, maybe this year, maybe next year, but I think you'll see in your legal careers the non-delegation doctrine make a comeback. Think everything? Okay, I have some questions from the students. Oh, thanks, Anthony.
We have time for just one question.
Are we done at 12:50? Oh, sorry, we've been quicker. I'm sorry. So questions, please. I'll be here for a while if you want. Questions from students, please. Yes.
You spoke about electability before.
Yeah.
What is your view on the constitutionality of current president
Sure. So first off, what's an executive order? An executive order is nothing special, right? An executive order is just a way of the president saying, here's what I'm instructing my people to do, my subordinates to do. There's nothing insidious about an executive order. What matters is what the executive order says. If the executive order merely says, Congress gave me the power to do X, so I'm going to do X, there's really not a problem. But if there's a debate about whether, in fact, the Congress gave this power, it's skeptical. Now, your question is whether one president can rescind an executive order of his predecessor. That's usually considered automatic, right? When President X comes into office, he just wipes out all these other orders from his predecessor. But in recent years, courts have actually held that President Trump has not done enough work to rescind the Obama-era orders. And I think those decisions are in doubt. I think the president should get some deference on this front. Okay. As people are packing up. Maybe one more question? Thank you all so much. It was a pleasure. Thank you.